discussion. If you understood appeals in the first week, then this one is going to be just a walkover, because it's just a repeat with a few modifications of what we discussed in the first week of criminal proceedings. But if you can listen up to the end of this video, I will give you tips on how to pass the final exams on criminal proceedings, in light of the fact that you're going to have almost 50 pages, and you're supposed to do all that in 4 hours. So if you can listen up to the end, I believe you will understand how I read record of proceedings. So this week involves a module that will equip students with skills required to institute and peruse post-trial remedies. In this module, students will be introduced to second appeals, which arise from magistrates' courts to the Court of Appeal. Further, they shall continue to deal with first appeals arising from the High Court of the Court of Appeal. So I believe that we looked at appeals from the High Court to the Court of Appeals in our first module of this term, and we shall be looking now from appeals from the magistrates' courts to the High Court as well as the Court of Appeals. So you understand that under the law we basically have 3 appeals: 1 first appeals, second appeals, and third appeals. So as far as the first appeals are concerned, if you read that case of Chifamunte Henry versus Uganda, you find that on first appeals, the trial court or the appellant court evaluates whether the trial court properly did its mandate. Then second appeals are always on matters of law and fact, and third appeals are only on matters of law. So far, they shall continue to deal with first appeals arising from High Court, the Court of Appeal. Focus will be on the scope of the first and second appeals permitted under the law, the procedure aspects of presenting and opposing such appeals permitted under the law, as well as the duties and powers of the respective appellant courts. Such remedies include appeals, applications for extension of time, and interlocutory remedies like bail pending appeal. Students will be exposed to the various procedure of attaining the most appropriate remedy in the circumstances of each case. The skills will be imparted to students through advisory and practical demonstrations or praise. So basically here we shall look at how do you apply for bail pending appeal. You understand that under the law you must lodge a notice of appeal within 14 days. If the 14 days have elapsed, then you seek leave to file a notice of appeal out of time. But basically the documents we have here will always be the notice of appeal together with the memorandum of appeal, which contains the grounds of appeal. Workshop 1, the aims of these workshops are to develop the ability to institute first appeals, develop the ability to peruse a record of proceedings, develop the ability to identify and formulate grounds of appeal, develop the ability to draft documents for an appeal, develop the ability to institute an appeal, and develop the ability to prosecute applications for bail pending appeal, and develop the ability to present and prosecute an appeal. By the end of this first workshop, students should be able to institute first appeals from High Court to Court of Appeal, peruse a record of proceedings and judgment, identify and formulate grounds of appeal, draft court papers necessary for institution of an appeal arising from the High Court, prosecute applications including applications for bail pending appeal, present and prosecute post-trial proceedings, and appreciate the power and duties of the first appellant court. So here we have statement of the offense. We have an indictment, statement of the offense, rape contrary to section 123 and 124 of the Penal Code Act, particulars of the offense to Muhimbise Francis on 7th of July 2020 at Chindi village in the Rukunjiri district, had an unlawful recurring knowledge of Kwichiriza Scovia, a girl aged 15 years without her consent. We also have the summary of the case. Then we also have a record of proceedings before Honorable Justice Boris Chifefe. From there we have assessors who are sworn in on Ace 1st 2025. We have re-examination of PW2 Lucena and Teza. Then on Ace January 2025, we have PW3 Katuma Jacob re-examined and cross-examined. We also have on 21st January 2025, defense witness number 1. The defense begins its case, so it's put on his defense to Muhimbise Francis, who is the accused. Then judge on 21st January 2025, all parties present as before. Assessors were in court. We advise my lord to find the accused guilty as charged. Loctus, we can see the loctus sentence and reasons in arriving at the sentence following our main considerations. I've taken into consideration mitigating and aggravating factors. All factors put together, the convict is sentenced to 30 years in prison. Then from there we have the judgment. We have the judgment before Honorable Justice Boris Chifefe. And if you can see the judgment, first and foremost, ingredients of the offense, the following ingredients which must be proved beyond reasonable doubt: sexual act, use of force or lack of consent, and participation of the accused person. And then the judge proceeds to convict the accused person. Then you can see alloctus and mitigating factors and aggravating factors. All factors put together, the convict is sentenced to 30 years in prison. I will have police for medical examination report. So we go to the workshop tasks. So far, I'm just done with reading the record of proceedings. And the grounds we can see: one is the trial judge didn't properly evaluate all the ingredients of the offense. Secondly, he ignored the defense of alibi. And then the sentence is severe and harsh. So basically, those are my 3 grounds which I'm going to rely on. And once I have those 3 grounds, then I'm good to go. So you don't need to read every word per word for you to understand that what you are looking for is the grounds. And you can always go to the judgment and peruse through the record of proceedings to see whether there are no procedural irregularities. So tasks: identify and discuss the substantive remedy available to the convict. We shall look at appeal, merits or grounds. One is that alibi was ignored. The trial judge erred in law and fact when he ignored the defense of alibi. Secondly, he failed to properly evaluate all the ingredients of the offense. And thirdly, the sentence was severe and harsh, even when he did not deduct the period which was spent on remand. Draft the necessary documents included in task 1. So we shall draft a notice of appeal and a memorandum of appeal in light of the fact that the judgment was passed on 18th, but I think these days have been revised. But as long as you are still within 14 days, you can lodge a notice of appeal and a memorandum of appeal. If the 14 days have passed, you can seek leave to lodge a notice of appeal out of time. For prepare record of appeal for the certification by the registrar. So discuss respondents and expected responses to the identified grounds. Basically, you just go to the judgment and try to rebuke the grounds. Basically saying that the court trial judge did everything within the law. Prepare record of appeal for the certification by the registrar. So the record of appeal has a notice of appeal, a memorandum of appeal. It has the record of proceedings, the judgment, and the sentence, among others. By overall pray, urge your client's post-trial remedy. By overall pray, urge your client's post-trial remedy. So basically, how shall be looking at the post-trial remedy? A post-trial remedy would be bail pending appeal. Bail pending appeal, which we shall be looking at basically here. So basically, that's it. That's it. I'll go to preparation for the workshop. We'll go to workshop 2. Workshop 2, the aims of these workshops are to develop the ability to institute the second appeals, develop the ability to peruse the record of proceedings and judgment, develop the ability to identify and formulate grounds of a second appeal, develop the ability to draft court documents necessary for an appeal, and develop the ability to prosecute applications for bail pending appeal, and also the ability to present and prosecute an appeal. So we have the notice of appeal here, together with the memorandum of appeal, and the proceedings in the Chief Magistrate's Court of Makinde. We can see proceedings for the appellant, Joy Martha for the respondent. Parties are directed to file written submissions as follows. Then we have 18/9/2024. Appellant is present for the respondent. My lord, to confirm receipt of written submissions. Land advocate, is that correct? Yes. Proceedings, you can see how they proceeded here. Then from there, this was on appeal. We have the judgment of Justice Elias Samueli, judgment of the High Court, which basically upheld the sentence and conviction of the magistrates' courts. So briefly, as you can see from the judgment, this is an appeal against conviction and sentence. The appellant was charged with 2 counts of theft contrary to section 254(1) and 261 of the Penal Code Act. The facts accepted by the trial magistrate were that the appellant in the month of June 2021 at Excellent Bank, Nasa Road in Kampala District stole cash amounting to Uganda shillings 15 million. The property of Martha Chisutu, that in the same month and of the same place, the appellant also stole cash amounting to 20 million belonging to Patience Funanji. During the trial, the appellant pleaded not guilty on each count, but was convicted upon a full trial, sentenced to 4 years imprisonment on each account, sentences to run consecutively. In addition, he was ordered to compensate the first and second victim a sum of 15 million. So you can run the judgment of this court. After careful perusal of the record of proceedings, the judgment, considerations of the submissions filed by the parties, and having addressed my mind to the law, I therefore find no merit in grounds 2, 3, and 4 as well. The appeal is accordingly dismissed, and the appellant will continue serving sentence as meted out by the land trial magistrate. Right of appeal explained. So from there we have the proceedings from the Chief Magistrate's Courts, how they transpired in the Chief Magistrate's Courts. This is not much of importance since we are looking at second appeals. So I just ran to the judgment of the Chief Magistrate's Court of Kampala at Makinde. You can see down all the ingredients of theft, how they were evaluated, and basically he was convicted, found guilty of theft. So workshop tasks: identify and discuss the most appropriate remedy available to your client. Here we shall be looking at second appeals. Court action is envisaged, draft the necessary court documents, notice of appeal and memorandum of appeal together with the grounds. But basically the grounds here, I shall be looking at the appellant, the land judge of the appellant court erred in law and fact when he basically upheld the conviction of the trial court. Secondly, the land judge of the trial court erred in law and fact when he failed to evaluate all the evidence on record as relied on by the trial magistrate, and also the land judge erred in law and fact by upholding the sentence and conviction. So basically here we can sentence and conviction, failure to properly evaluate the evidence of the trial court, among others. So by way of written submission, discuss the merits of your client's case that you shall highlight or at the hearing. We shall expound on those grounds, discuss the respondents and specific grounds for opposing the remedy envisaged in A. You just have to affirm that the appellant court did the right thing. In the event that you are informed by the court's registry that there are no funds to hold a criminal appeal session soon, discuss the interim remedy available of the convict pending hearing of appeal. This one would be bail pending appeal. draft the relevant documents, which is a notice of motion and affidavit in support. So basically, that's what we are going to be looking at for as far as week 2 of criminal proceedings is concerned. You can basically read the case of Chifamonte Henry versus Uganda, as it governs as far as first appeals, second appeals, and third appeals are concerned. So basically, that is it for this week. Just have to master the art of perusing these record of proceedings. Just like the way you have seen, you pay attention to the judgment and confirm whether there are no procedural irregularities in the record of proceedings. And once you have the grounds, then you are good to go. Actual appeals can become the very easiest to do. So please, I wish you success in your IA, and please have a blessed week.